a person commits a wrong, so that the wrong cannot be repeated in future, so that for that reason he has to be punished. So that is the very reason why preventive detention is added under Indian Constitution. So in today's video, we are going to understand Article 22 of Indian Constitution in depth. We will understand what preventive detention is, what are the safeguards that have been used or added in the very Constitution itself. So let's get started. So let us know first what is in Article 22. Article 2 of the Indian Constitution provides for preventive detention law. So all the preventive detention law will be added or is added under Article 22 of Indian Constitution only. Preventive detention means arresting a person not because they have committed a crime but to stop them from doing so in the future. So this is the very meaning of what is preventive detention. If a person has committed a crime, for example, A has murdered a person B, so A would be arrested not only for the reason that he has killed a person, but that so he won't repeat his crime in near future, and for the betterment of the society he has to be arrested. So that is the very reason of preventive detention. This kind of detention is generally considered undemocratic, but the constitution allows it to protect the nation's unity and integrity, especially in the early years of independence. So this arresting A on behalf of his crime was sound undemocratic during the era of independence, but for the betterment of the society, this has been added and accepted. Since preventive detention can be misused, the Constitution also provides several safeguards under clauses 4 to clause 7 of Article 22. But preventive detention has the highest probability to get misused by the person. So, in order to curtail the misuse, so there are various safeguards have been added under the Article 22 of the Indian Constitution from clause 4 to clause 7. So this is the very meaning of what preventive detention is, which is under Article 22. Now let's move into the safeguards that have been mentioned in Article 22. Grounds must be communicated. So this is the very first safeguards given under the preventive detention. The detainee must be told why they are detained as soon as possible, and it is written under Article 22 clause 5. For example, A has been arrested for a crime and he has not been told for why he has been arrested. So he has the right to know on what grounds for what crime he has been arrested by the authorities. Grounds must be clear, specific and understandable. Again, the grounds need to meet the certain necessities. It has to be clear, it has to be specific, it has to be understandable. You cannot come up with a vague or illogical ground. It has to be very clear and should be understood by the people in general. No hidden or vague reasons allowed. As I said, there shouldn't be any vague reason given to the person who is arrested. Important cases. So Indian Constitution is all about the case law precedent. So in this manner also we have some various important case law which we will be understanding throughout this very video. First we have State of Bombay versus Atma Ram. Grounds must be clear. So in this case the court says that grounds must be very clear and this is a valid ground. You cannot come up with any vague representation or any vague reason. Next we have Abdul Aziz versus Delhi administration. Delays can make detention illegal. So if you are delaying in giving the reason properly, it can make the detention illegal. Now let us move into the safeguard number 2. It is right to representation. So this is the second safeguard in this manner. The detainee has a right to make a representation, for example, defend himself. So that's because he is a person who has done something wrong. That person he is arrested. It doesn't mean all the right has to be snatched away from the person. If he has committed a wrong, and he should be given the authority, or he should be given the chance to defend himself from his side. The government must consider the representation, and the government has to consider his representation. Applies to all detention cases, short or long. So it doesn't has any criteria. For example, for short cases, the representation should be added. It doesn't have any certain essential. So for any case, the detainee has the right to represent his own case. So in this manner, we have also an important case, that is Punkaj Kumar versus State of West Bengal. Government must consider a representation even if the advisory board is also allowed. So it says must. So there is no other option for the government to deny his representation. So he has to consider the representation. That is the second safeguard on this manner. Now we're understanding what is the dual role in considering representation. There is a dual responsibility in preventive detention cases. So what it says, it has dual role. Now we will understand whether the person for whom the role has been vested upon. First, the government must consider the detainee representation to ensure that detention follows the law. The first role is for government to ensure the detention follows the law. It has to be legally followed. You cannot come up with your own authority, own actions. It has to follow the legality. Second, the advisory board. The advisory board is the second one, must also review the case to see whether the detention is justified. So a advisory board has to check the review of the person who is detained or arrested. Board have to do their duties independently and properly. So they has to do their investigation separately, not linking with each other. If there is any delay by the government in considering the representation, the detention becomes illegal. So it is on the government to check all the necessary information, and there shouldn't be any delay, otherwise it will make the detention illegal. Now let us understand the third number safeguard regarding this manner, which is advisory board review. Article 22 provides that a detained person has the right to get their case reviewed by an advisory board. So A has the right so that his case has to be reviewed by the advisory board. The board finds that the retention is not justified, the person must be released immediately. If the advisory board feels that A has been arrested illegally and is justified, A has to be released immediately. If the board agrees with the detention, the government can decide how long the person should be held. If advisory board feels that yes, A is guilty, then the government has the power to decide from how long the person would be punished. Uh, The 44th Amendment to the Constitution changed the rule of the board. So here's come the 44th Amendment Act, which has importance in this manner, and it has changed various things regarding to the Preventive Detention Act or detention laws. It must now have three members, a sitting High Court judge as the chairman. So it says the advisory board has to at least 3% in total. A sitting High Court judge is the first one to be appointed as the chairperson, and two other judges who can be either sitting or retired. So this is the very much requirement or appointment of the advisory board, which came after 44th Amendment Act. Now let us move into the legal assistance before the advisory board. So what happens before the advisory board? Normally, the detained person cannot have a lawyer when representing their case before the advisory board. So basically, the person who is detained does not have the right to get for himself a lawyer representing his case before the advisory board. However, the government is allowed to use legal help. The detainee must be given the same chance to ensure fairness, but the government is allowed, so why not the person who is arrested? All the reasons and procedures has to be fair for both of the parties. This is based on Article 14 and 21 of the Constitution. So based on the Article 14 and 21 of the Constitution, both has to be given the same kind of opportunity to represent their own side. In Nanlal versus State of Punjab, the court held that the board decision to allow or deny legal help must be fair and not arbitrary. So this is also a very important case in this manner. In this case, it has been said that the board decision to allow or deny legal help must be fair and arbitrary, not something which will be beneficial for one party only. It has to be fair and arbitrary. Now let us move into the emergency and detention. So during emergency, various rights have been suspended. So in this manner, we have very important two case laws. For example, one have ADM Jabalpur versus SS Sopur. The Supreme Court held that during an emergency where Article 21 is suspended, people cannot go to court to challenge their detention. This meant court would not check if the detention was done with bad intention. So this is the decision given in the ADM Jabalpur case. So what has been said? It says that during emergency, certain article got suspended, like Article 21. So if during that era, if a person got arrested, he doesn't have the right to ask for his legality during the court. If there is misuse of his arrest, in arresting the person, there also he doesn't have any right to seek justice in the court. But what happened in the next case that we have in Makhan Singh versus State of Punjab, the court had earlier said that detention can be questioned if it done with malice or if rules were not followed. But in this case, the decision has been given that is contradictory to the decision given in the previous case. It says if the detention follows malice, then this conflicting, a person has the right to seek justice in the court. This conflicting judgment cause confusion of the powers of the court during emergency. So both two cases, contradicts with each other judgment. One says you cannot, one says you can. So this is the very two important case law regarding emergency and detention. Now let us understand what is the importance of 44th Amendment Act. Amendment. So the 44th Amendment to the Constitution made important changes to protect individuals' freedom. It reduced the period of detention without advisory board review from 3 months to 2 months. It says earlier the government has all the right whether to how many time for how many time the person should be detained, which has been changed after 44th Amendment, and it has been reduced to 3 months to 2 months. Most importantly, it said that Article 21, which guarantees the right to life and liberty, cannot be suspended even during an emergency. And it also says that Article 21 cannot be suspended even during emergency also. This means the court can now review detentions during emergencies and ensure they are lawful. So if any person has been detained during the emergency era, the court can review his case and will decide whether the detention was legal or illegal. The amendment greatly strengthened the protection of personal liberty in India. So, 44th Amendment is kind of a step for stronger protection. So, this is all about what article is relating to preventive detention. So, soon we'll be meeting with another legal updates. If you see this video worth watching, to share, like, and subscribe. We'll be meeting soon with another legal updates. Thank you for watching the video.